course, Mr. Camp.
What's the courtroom got empty real quick after that? You drove everybody off?
Obviously the least popular of the group, I can assure.
Not that your case isn't important.
I understand, sir. No, that's not a problem. It did seem like they did bring their entourage with them, no question about it. May it please this honorable court, my name is David Camp, and I represent the defendant, Bobby Neal Mathis, Jr. At this time, with the court's permission, I'd like the opportunity to reserve 5 minutes for rebuttal, if I may, please.
Okay.
I will begin, of course, by thanking the court. The court asked me at this point to step in and represent Mr. Mathis in regards to the appeal. I did not have the opportunity to represent him at the trial level, albeit I did have the opportunity and more than enough time to review the transcripts and the record in this matter in order to present the argument that we're presenting here today.
And we do appreciate that.
Yes, sir. In relation to that, if the court please, this seems to be somewhat limited in issue, and frankly, it's a question that the court, I think, has wrestled with before, and I think certainly should wrestle with again in this matter, and that's the question of election of offenses and also what I call the modified unanimity jury instruction, neither of which were done in this case at the trial level. Now, one point that I think in reading the state's brief, I think it would be conceded, number one, even though election of offenses was not raised at all at the trial level, that does not waive that argument before this court, and I think that's black letter law. And as the court is well aware, election of offense puts a burden on the state to specifically identify and set out those facts upon which the state would be relying upon in order to prosecute Mr. Mathis for the allegations and charges in this case, not only, of course, of count one, where he was charged with, I believe, rape of a child, and then secondly, I would contend to the court it continues on to continuous sexual abuse of a child, which is count two. I would also bring out to the court's attention that he received a 30-year sentence and that the counts 1 and 2 were merged at sentencing in this case, as has been set out by the state and agreed upon by the defense in this matter. So the history of this case presents in this matter, if the court please, that on March 21 of 2021, the police were notified of allegations that the minor child, who goes by the initials of AS, had been sexually assaulted by Mathis. Mathis, of course, apparently was living in the home. One of the issues that came up during the course of the trial, which I think is critical for the court to consider, is that Mathis did not continuously live in the home during the time period identified in the indictment. The indictment identifies in count one that allegedly the rape of the child occurred between March 10th of 2021 and March 20th of 2021. Police having been notified on March 21st of 2021. But more importantly, the continuous argument of the sexual abuse of a child is alleged to have occurred between May of 2019 and March of 2021. Now, as often the case when children are interviewed, in this instance there was a video played for the jury of the child's interview being conducted in this case by Dr. Lisa Piercy. There was no specifics given by the child as to when these particular incidents had occurred. In other words, she even made the comment it had occurred almost every day as it relates to the sexual abuse. The problem that presents in this case, if the court please, is that Mr. Mathis, and I got these dates down I think for the court to reference, that Mr. Mathis basically moved into the home in May of 2020. Now mind you, this is supposed to have begun in 2019, that he was there for about a couple of weeks. This is in the record. He left in June of 2020 because he was in the military, so he was doing service overseas in Afghanistan, and was gone until October, I believe, 4th of 2020. So he wasn't even there for those incidents to have, quote unquote, occurred almost every day, as was testified to by the minor child. So what is the solution when that happens? The solution is actually very direct, and it's supported by case law.
Actually, before you leave that, what was the end date of the indictment?
Your Honor, the end date of the indictment, Judge, for this is in count 2 on the contagious sexual, would have been March of 2021.
All right.
So we go May of 2019 to March of 2021. That's about 22 months. But contained within that date, That's the March 10 of 2021 to March 20 of 21. So the end part of that is when the rape is alleged to have occurred within that quote-unquote 10-day period, while at the same time continuous sexual abuse is supposed to be ongoing, as testified to by the minor child. Now, as is the case, unfortunately, as we see in so many circumstances, there's no physical evidence to support that a rape ever occurred. Dr. Piercy conducted an examination and could not find anything to evidence that. Secondly, of course, there's no one saying that this occurred except for this child. So we get in again to these circumstances where the child makes allegations about events having occurred. Of course, the defendant in this case denies that any such events occurred, and then it becomes a question of defending against the allegations that has been asserted. The gravest concern, and I've identified for the court, and the state in its brief made a statement, I think, and I believe it's on page 30 of the government brief, that there was no assertion of any authority cited about the issue about the modified unanimity instruction. And I'm not trying to bounce around, I'll tie all this together. But the problem is that the state makes that assertion, but in fact on page 15 of the appellate brief, we did in fact cite authority for the court to consider as it relates to that issue regarding the modified unanimity instruction. And so allow me to tie that up if I may. The purpose of the election of offenses has been set forth and identified in so many cases. These cases, of course, also having been cited, I cited for the court State versus Hodge on page 15. In relation to a portion of at least what that says. And what it says under election of offenses in this case is that the right to jury unanimity involves not only the requirement that the jury be unanimous as to which offense constitutes the crime for which a defendant is convicted, but also the right to unanimity among the jury members as to the specific act which constituted the offense. So what this ties down to is very simple. In order to avoid the risk of jury unanimity not being met, which is constitutionally an entitlement that Mr. Mathis had, the jury has to be specially directed through a modified instruction saying, this is what the state is seeking to prove are the facts beyond a reasonable doubt that should result in your determination on whether he's guilty of the crime as charged. Otherwise, what the problem is, the jury gets back and starts deliberating, and are they saying, okay, we're going to find him guilty beyond a reasonable doubt on the fact he did this every day? Are we saying that, are we finding him guilty beyond a reasonable doubt that he did it during this time period?
Mr. Campbell, let me stop you for a second.
Yes, sir, Judge Campbell.
Count one,
Yes, sir.
which is a 10-day period,
Right.
alleges one event.
That's correct.
Okay, so there is no need for unanimity there.
Well, the problem, Judge, is that the confusion created by the fact that there's not really clarity in the child's testimony as to specifically how that rape would have occurred other than the touching type, which is no different, quite honestly, than these other allegations that she was claiming occurred through sexual abuse.
But the jury was charged with child rape, with rape.
That's right.
Child rape. For that count, we're talking about that particular count, which
That's
is
correct.
a standalone thing.
Yes, sir.
And the jury was instructed on the definition and on the elements of the offense. And they came back with a guilty verdict on that one offense because that was all that was alleged in that count. I'm talking about count two where it alleges a lot of other things.
I know that.
But as far as count one is concerned,
Yes, sir.
it was one incident.
Yes, sir.
So either the jury would have found that it didn't happen, it would have been a not guilty. I guess they could have considered lessers because there were lessers given, but they came back with guilty of that event, of that charge.
Under the count one, that's
Under
correct.
count one.
That's right.
So you're saying in count one, they would still need to have charged to them the modified unanimity charge?
I believe that the jury should have been specifically instructed that they are to consider that count in and of itself separately and apart from the other count as it related to the quote-unquote ongoing activity, because the facts as testified to by the child were overlapping. And there was obviously concern in this regard when you read the record that there was not enough clarity as to specifically, one, of course, exactly when within that 10-day period this alleged rape is supposed to have occurred. The child could not give a specific on that. There was no day or date.
And you know that's not uncommon for, and I guess what I've seen in cases like this where you have a large, you know, number of days in the indictment, like a 2 or 3 month period, and the child alleges different things, the state has to elect which one they're going to present to the jury. The jury can hear all of the other matters, but they have to be unanimous of the judge. The state has to come in and say, in this count, we're proceeding on this one incident that happened at this particular place, whatever it is. And that's the requirement for unanimity. I haven't seen a case where, in a particular count, where there's one event alleged that you require unanimity, unanimity charge.
And in response to that, the problem you have is you read count 1 in conjunction with count 2, and the dates overlap.
I understand, but the jury is instructed they have to consider count 1 alone.
I don't disagree, Judge Campbell, and that's correct. So the question is, are we looking at an election of an offense in that date? I don't know that we could be, if there's one incident occurred within it. But the problem is when you overlap that into the situation where it does include also the allegations of continuous sexual abuse occurring within that same time period, what would be the harm to the defendant's right to agree to at least securing a unanimous verdict by specifically instructing the jury at that point in time that that you have to consider this separately and apart from count 2, and you have to make a determination that you can't overlap your deliberation or make a decision based on the facts that may have occurred regarding both at the same time. And that's the problem that I'm seeing as far as what took place, is not so much what did happen, but what didn't happen. And that's what the position of Mr. Mathis would be, if the court please, as to those particular instances, because you cannot differentiate or distinguish the two unless the jury's instructed to do so. Now, the state seems to raise an interesting point here to say that, well, if that's the case, it didn't get asked for in the jury in the trial level, ergo it's waived. I would submit to the court that you can't distinguish the two. In other words, if election of offenses have to be, they don't have to be raised, and I think we all agree with that. You can't waive those. A modified unanimity instruction goes hand in hand with the election of the offense. In other words, why are you instructing the jury specifically as to incidents that occur to assure the jury comes back with a unanimous verdict? That's what election of offenses is, the same deal. So I would submit to the court that even though it was not raised, and I would concede at the trial level that the request for a modified unanimity instruction was not made in this instance, the point of the fact is that I don't see anything that says that it's waived if it isn't raised. Because if that's the case, then election of offenses have to be raised at the trial level as well. And we know that's not the case, and that's black letter law as far as that's concerned. So I would submit that the waiver did not occur. I would contend, if the court please, that as a direct result of the trial court's failure in this instance to, one, require the election of the offense on the continuous sexual abuse, and second of all, to require a modified unanimity instruction because of the overlapping indictment dates, that there was in fact reversible error committed. His constitutional rights were clearly violated, and we would ask the court reverse the conviction under the circumstances. Court, please. Thank you.
Thank you, Mr. Campbell.
May it please the court, Brent Cherry for the state. The defendant was convicted of 1 count of child rape and 1 count of continuous sexual abuse of a child. And the victim, who was 12 years old at the time of trial, testified about the events that constituted these offenses. She testified that she used to live with the defendant, that he was in a relationship with his aunt. She affirmed the police came to her home in March of 2021 and arrested the defendant. They took AS to the Child Advocacy Center, where she spoke with the lady about the abuse she received at the hands of the defendant. The recording of that interview was played for the jury. During the interview, AS detailed several specific instances when the defendant sexualized her. As far as election of offenses is concerned, the defendant argues that the state failed to make an election of offense at the close of the state's case in chief, but no election was necessary, as I've laid out in the state's brief. In many child sex cases where the abuse has been by a family member in the home, the child victim speaks about multiple instances of abuse over some period of time. And it may be necessary in those cases for the state to connect a specific instance with the corresponding count of the indictment to charge that specific instance of abuse. And one reason for the election is to give the defendant notice of what he has to prepare for at trial. Another is to enable the court to determine the sufficiency of the evidence to support that specific conviction. And yet another reason is to avoid double jeopardy, so the defendant isn't being punished for multiple times for the same event. In this case, we have count one that charged rape of a child. The defendant was charged with an offense that occurred on or about March 10th, 2021 through March 20th, 2021. And at trial, the state presented evidence of only one rape during that period.
Is that the rape where she was first interviewed? I think it was Miss Edge, and she said, "He raped me about a week before." Is that the one?
Yes, Your Honor. And that's the only event that she spoke of that fit within that particular time frame.
But what the defense is asking is, from what I can tell, I'm sure on rebuttal he'll say if I'm stating this correctly, is because of count two, it talks about multiple events that occurred during this entire period of time, that it became incumbent upon the state to get the jury to commit to a particular event in count one so that there wasn't some confusion about, these other allegations that were made, some of it overlapping during the time that this rape occurred.
Well, Your Honor, when we're talking about the overlapping, this, it's interesting because the continuous sex abuse of a child is a relatively, we don't see that as commonly as we do just a string of rape of a child cases. And with continuous sex abuse of a child, it's a little bit different in that the jury has to determine over a particular time frame that a number of offenses has occurred. Now, in this case, we have one event that's charged individually in count one, and that same event constitutes one of several offenses that constitutes continuous sex abuse of a child. So in that respect, I suppose you could argue that, yes, there's some overlap because that same event is considered in each of these counts. But there's no question in count one of what we're talking about. We're talking about that event that happened on that very narrow time frame a week before the interview at the Child Advocacy Center. So there's no question about what we're talking about there. When we move on to talk about election of offenses with respect to continuous sex abuse of a child, we've got a very different kind of animal in respect to how the law operates in terms of these specific events. And as I've laid out in my brief, the state is not required to specifically state which offenses are going to constitute, in this case, a minimum of 3 events, 3 specific rapes or abuses otherwise, that would constitute that continuous sex abuse of a child. The jury can look at a number of offenses, a number of incidents of abuse, and as long as they agree that 3 or more happened during that time frame, that's enough. They don't have to agree that it's this one on this particular date and this one on this particular date and this one on this particular date. They just have to agree that there were 3. And there can be some lack of unanimity, if you want to call it that, in terms of which events constitute the continuous sex abuse of a child.
How does his absence from the home, especially when he was in Afghanistan or wherever he was, how does that come into play when we look at the sufficiency of the continuous sexual abuse of a child?
Your Honor, we have a pretty definite time frame as to when he first moved into the home. I think it was April of 2020, or March or April of 2020, as I recall. And the abuse started, A.S. testified that it was just a couple of weeks after that he moved in that the touching began. And then we have several events she testifies to, with the last one in March of 2021. So we have that time frame that extends over a period of more than 90 days. Now, whether he was there for the full 90 days or not, that's a question for the jury to look at and determine. He was able to testify, hey, I wasn't here during these particular dates, but if this happened a couple of weeks after he moved in, ended in March of 2021, and there were other events that happened, now whether they were after or before the time that he left, as long as the jury agrees that there were at least 3 instances, then that sufficiency is met. And again, that's a question for the jury to look at. They were able to listen to the testimony, measure the credibility of the witnesses, and determine whether this was established beyond a reasonable doubt, and they did that. Again, and I don't know that I need to spend a whole lot of time on this. The court is familiar, and I think I've laid out in my brief how the continuous sex abuse of a child works with respect to election, and I've also addressed in my brief the fact that as the state closed its case, it went through and laid out exactly what offenses, what incidents of abuse they were talking about, and that can be a sufficient substitute for an election if this court were to determine that one was necessary, which it wasn't. There's a statutory requirement for the state to provide a notice about the events or the incidents of sex abuse of a child for that count, and the state complied with that requirement. And again, the state laid out each specific instance when it gave its closing argument. So the jury knew what the state was talking about. They knew what the state was pointing to. The defendant had an opportunity to challenge these specific instances and raise his own arguments and talk about when he was there and when he wasn't. And the jury was left to determine what the facts were that were established, whether it was beyond a reasonable doubt, and they did that. So with that, the state would encourage the court to simply affirm the judgment of the trial court, unless the court has other questions. Thank you.
I'll be very brief, but I do want to respond back, if I may, to Mr. Cherry's statements or argument there. First and foremost, the election of the offense has to occur at the close of the state's case in chief. It's not to be brought out in closing argument. And that's a very significant distinction because that's done preceding the defense initiating its proof. And this...
Is it your position that the state would have to elect specific offenses in count 2?
I do. And I know what's being submitted and argued by the state in this case, but the problem you have is this 90 days, occurring within 90 days and saying, yeah, there's 3 incidents that occur, doesn't specify which particular incidents. They're just saying there's 3 incidents that occur, and those have to be specified in order for the defendant to understand precisely what he's defending. In addition, that notice is not provided to the jury. It would not have created harm, nor would it have created issues for Mr. Mathis. It would have actually assisted him in assuring that he got a fair trial if the state had made that declaration at the conclusion of its case in chief and made that known. At that point in time, that could have been presented as far as a defense in regards to Mr. Mathis's charges. That does not negate the court's responsibility, again, to have given that instruction, and the court did not do that in this instance, and that should have been done regardless. So even if we get beyond the election issue, to avoid the likelihood of confusion, it would have required this court to have at least given that instruction to at least tell the jury, you've got to identify with specificity these acts and determine whether these acts occurred beyond a reasonable doubt. And that's what a modified unanimity instruction is about. Otherwise, it's a grab bag. And that's what specifically has been talked about. And I bring back the Hodge case, where it says very clearly, a conviction that is not unanimous as to the defendant's specific illegal action is no more justifiable than a conviction by a jury that is not unanimous on a specific count. And again, that is black letter and has once again been brought out repeatedly. I would also cite again from Hodge, when the state presents proof on many offenses within an alleged time period but neglects election, the jury is allowed to reach into the brimming bag of offenses and pull out one for each count. How do you defend that? And the answer is you can't, and that's the problem that's presented here. And I would submit to the court that's sufficient to create reversible error, and we ask that the court in fact do so. Thank you.
Thank you. call our last case of the morning, please, Madam Clerk?